Now, the big reveal that happened today was the 20th Amendment to the Constitution. It was gazetted and made available to the general public. Now, what really is the content of the 20th Amendment to the Constitution? It has to be placed on the Gazette for 14 days before it can be placed on the order paper of Parliament, and that 14 days count begins from today. How drastic really are the changes that have been proposed by the 20th Amendment to the Constitution? Here are a few, but before we get into the changes that have been proposed by the 20th Amendment to the Constitution, it must be said from the onset that the 19th Amendment to the Constitution has not been completely repealed by the proposed 20th Amendment to the Constitution. Before we get into the differences or the sections that have been repealed or have been proposed to be repealed, let's take a look at what has been preserved from the 19th Amendment to the Constitution. Firstly, the President's term that was limited to 5 years has continued to be in place. That provision has not been repealed. Also, the two-term limit that was imposed on a person to hold office of President has also not been repealed by the 20th Amendment to the Constitution. Moving on to some of the changes that have been proposed, or certain sections of the 19th Amendment that has been repealed, one of the most prominent of the provisions of the 20th Amendment is the immunity that has been conferred on the President. Now, initially, if you can remember, the 18th Amendment to the Constitution had blanket immunity on all actions of the President. No civil or criminal suit could have been filed against the President. However, the 19th Amendment to the Constitution changed this and allowed for fundamental rights applications under Article 126 of the Constitution to be brought against the Attorney General for actions or inactions of the President that could amount to a violation of a person's fundamental rights. But the 20th Amendment to the Constitution has now proposed that the President be given full blanket immunity back again, almost as if we are reverting back to the situation that prevailed under the 18th Amendment to the Constitution. Another big talking point, of course, in the run-up to the election, following the presidential election, even in the run-up to the general election and following that as well, is the Constitutional Council and its role. However, if the 20th Amendment to the Constitution is passed, that would be a thing of the past, because constitutional councils have been completely abolished under the 20th Amendment to the Constitution. However, it has been replaced by what is called the Parliamentary Council. However, the powers of the Constitutional Council and the Parliamentary Council are like the sky and the earth. They are completely different, because the Constitutional Council had substantial powers, especially when it comes to appointments to high posts like the Attorney General, the Inspector General of Police, the Justices of the Supreme Court, the Chief Justice, and of course the appointments to the independence commissions, including the Elections Commission, the Audit Commission, the National Procurement Commission, so on and so forth. However, under the 20th Amendment to the Constitution, the Constitutional Council has been completely removed, and it has been replaced by a Parliamentary Council, as I said before. Now, the members of the Parliamentary Council, of course, are appointed nominees of the Prime Minister, Leader of the House, and also the opposition leader, the nominee of the President, and also the 3 members of civil society that were previously included in the Constitutional Council have also been removed. So, by essence, the Parliamentary Council will not have civil society representatives as opposed to the Constitutional Council, which did before this. Also, speaking about the powers of the Parliamentary Council and the Constitutional Council and how they are different, now I mentioned to you that the Constitutional Council exercised substantial powers when it comes to appointments to high posts, including the independent commissions. However, the Parliamentary Council, quite on the other hand, exercises only observatory powers. They are only there to give observations to the President regarding certain appointments, especially to high posts, and that also at the discretion of the President. So, in essence, the President has retained or regained his powers to make appointments to high posts, much like the situation that was prevalent in Sri Lanka under the 18th Amendment to the Constitution. Just a bit of a recap, the Constitutional Council used to approve the nominations that were sent by the President to these high posts. However, the Parliamentary Council will not engage in such approval procedures. They will only provide observations on these appointments. However, the transitional provisions that have been included in the 20th Amendment to the Constitution allows for the members of the Elections Commission, the Public Services Commission, the National Police Commission, the Human Rights Commission, the Commission to investigate allegations of bribery, corruption, the Financial Commission and the Delimitation Commission to continue to hold office. Now, however, two commissions have been abolished, and these two commissions are the National Procurement Commission and the National Audit Commission. And as such, the National Audit Commission, with the abolishment of the National Audit Commission under the 20th Amendment to the Constitution, we will revert back to the appointment of an Auditor General to oversee the functions of the National Audit Commission, or to perform, rather, the functions of the National Audit Commission. Now, we were speaking about appointments to high posts. Of course, it has been quite a controversial topic for quite a long time now. However, the 20th Amendment to the Constitution has proposed that the appointments to the position of Chief Justice, Justices of the Supreme Court, the Chairman of the Court of Appeal and the Justices of the Court of Appeal, members of the Judicial Services Commission, even to be appointed by the President. So the President will once again get the powers to make these appointments, especially the Chief Justice, important appointments to high positions in Sri Lanka. Also, the President will, however, as I mentioned before, the Parliamentary Council will provide observations to the President on these appointments that he is making. However, these are only observations, and this is the situation that prevails, of course, for the appointments of that I just mentioned, including the Chief Justices, Justices of the Supreme Court and the Court of Appeal. Also, the President may appoint the Attorney General. Now, these appointments, again, previously had to be endorsed by the Constitutional Council. That requirement has been completely done away with the abolishment of the Constitutional Council. The President has the power to appoint the Attorney General, the Parliamentary Commissioner for Administration, also known as the Ombudsman, and also the Secretary General of Parliament. Now, one main criticism of the 19th Amendment to the Constitution, especially after the April 21st attacks, was the fact that the President really could not remove the Inspector General of Police. And the current situation in the country also is in that context, as we don't have an Inspector General of Police per se running at the head of the police department. It's currently an acting Inspector General of Police that is running the show. However, the 19th Amendment to the Constitutional Council has now proposed to remedy this situation in that context by removing, of course, a requirement of the Constitutional Council's approval to change the position of Inspector General of Police. The President now, as I mentioned before, has the power to appoint members of the National Police Commission. And the National Police Commission will appoint the Inspector General of Police, and in essence giving the President really the power to appoint the Inspector General of Police as well. Now, onto a more pertinent topic that is currently in discussion. Does the President really have the constitutional right to hold a ministerial portfolio? Now, a backstory to this is the fact that the President did have a right to hold a ministerial portfolio. However, the 19th Amendment took away that power and introduced transitional provisions for President Maithripala Sirisena to hold the Ministry of Defence and also the Ministry of Mahaweli Development. However, President Gotabaya Rajapaksa, after his appointment, took over the Ministry of Defence. Now, there was a debate as to if the President really has the power to hold this ministerial portfolio. There were arguments presented that there are pre-existing provisions in the Constitution that cites the President as the head of the Triforces, and thus he has the power to hold the Ministry of Defence only. But the 20th Amendment to the Constitution really has flipped this debate onto another side by allowing the President sweeping powers over the Cabinet. Previously, the President had to obtain the the approval or the views of the Prime Minister in appointing his cabinet, and also the President's power to remove the Prime Minister was also limited through the 19th Amendment to the Constitution. And of course we are well versed with this area of law, especially even the general public, because of the constitutional crisis that the country faced in 2018 after President Maithripala Sirisena dissolved his cabinet on the 26th of October. However, the 20th Amendment to the Constitution has introduced the President, or cited the President as the head of the cabinet, a member of the cabinet, and given the President the power to appoint any minister or to assign any portfolio to any minister that he pleases. And again, the role of the Prime Minister in granting these appointments also has again been reduced to an observational role. The Prime Minister can provide observations to the President on these appointments that he makes. Now, another controversial topic that Sri Lanka has been grappling with is the Cabinet of Ministers. Is the Cabinet of Ministers in Sri Lanka too big? Is it too small? According to my knowledge, we currently hold the world record for the biggest Cabinet of Ministers in the world at a time. But the 20th Amendment to the Constitution has removed the cap on the number of ministers that can be appointed. The current under the 19th Amendment, of course, that is currently active, the cap on the number of ministers is 30 and non-cabinet ministers is 40. This cap has been completely removed, and the President has the discretion to appoint any number of cabinet ministers, non-cabinet ministers, including deputy ministers and state ministers, to his government. This is a huge power, once again, that was initially removed by the cap that was imposed on the number of ministers appointed. However, this has been given back to the President. Another provision in the 20th Amendment that was gazetted is the fact that the President can now dissolve Parliament within 1 year of the Parliament being appointed. Previously, the limit as to how long the President cannot dissolve Parliament was set at 4.5 years. This 4.5 years has been brought down to 1 year, and now the President can dissolve Parliament within 1 year of the Parliament being appointed. Also, the age limit that was introduced on any candidate contesting the presidential election has been reduced from 35 years to 30 years. So if you are above the age of 30 by the time the next presidential election comes around, you too have the opportunity to contest for the position. Another controversial topic really that was also discussed broadly in the run-up to this 20th Amendment to the Constitution being gazetted is the requirement or the disqualification that was placed on dual citizens to hold office both as President and as a Minister of Parliament. The 20th Amendment to the Constitution has removed this disqualification, and as such, if the 20th Amendment to the Constitution is passed, dual citizens will also be given the opportunity to hold a seat in Parliament and contest for the general election. Previously, also, the Elections Commission, now as I mentioned before, the appointments to all the commissions are made by the President. Now this includes the Elections Commission as well. The President also has the power to appoint a chairman of the Elections Commission as well. Speaking a little bit about the media and how the media functioned, especially during the run-up to the elections, the 20th Amendment has proposed that the Elections Commission that is appointed by the President will not only have the power to do all that is necessary to ensure that state media institutions comply with the guidelines that have been provided by the Elections Commission, especially during the run-up to an election, but the 20th Amendment has imposed a duty on all media institutions to comply with the guidelines that have been issued by the Elections Commission. Of course, these are only a very few or some of the main changes that have been proposed to the Constitution through the 20th Amendment that was gazetted. There are many more provisions, especially procedural matters, that have also been included in the 20th Amendment to the Constitution. Of course, the 20th Amendment to the Constitution will continue to be broadly discussed, especially in the coming weeks, in the 2 weeks that it remains in the Gazette until it is placed on the order paper of Parliament, and even after that, this debate will continue. And we at News First here are ready to provide you with an in-depth analysis of the 20th Amendment to the Constitution, what it really means, and how will these amendments affect you, the general public of Sri Lanka, in the future. Now, this was gazetted today, and many members of the civil society, the general public as a whole, even politicians, have begun to express their stance regarding the 20th Amendment to the Constitution.